And he asked, what can't Christians do that others can? And I pointed out things like the efforts to mandate prayer in school, posting the Ten Commandments in classrooms, and policies that allow federal workers to openly advocate religion at work. And his reply was that there's no separation of church and state in the law, because those exact words aren't in the Constitution. But decades of court rulings have built that principle out of the First Amendment Establishment Clause. And that's another classic Dunning-Kruger example, quoting one line without understanding the broader and legal historical context. And
although the phrase separation of church and state does not explicitly appear in the Constitution, the U.S. Supreme Court case law has long interpreted the Establishment Clause of the First Amendment to encompass this principle. Key cases supporting this include Reynolds versus United States, 1878. The court referenced Thomas Jefferson's letter about a wall of separation as an authoritative interpretation of the Establishment Clause. Everson versus the Board of Education, 1947. Now, I was alive on both of those. The case explicitly upheld the concept of the wall between church and state, prohibiting the government from breaching that separation even while allowing certain accommodations. Engel versus Fatale, 1962. The court ruled unconstitutional the official sponsorship of prayer in the schools, reinforcing the prohibition of government endorsement of religion. And boy, that was controversial. And I remember that, and I'm telling the truth. And then Lemon versus Kurtzman, 1971, introduced the Lemon test to ensure that laws do not excessively entangle government with religion, maintaining a balance rather than total separation. So the common thread here is that overconfidence that comes from partial knowledge. We have almost 150 plus years of jurisprudence from the nation's highest tribunal saying that's actually what is in the Constitution the way we're interpreting it.